Hello, everyone. Welcome. Thank you for coming to this final seminar of the day on Subject Access Requests, or SARs. I'm Rebecca Reilly-Cooper, a Senior Policy Officer in the ICO's Regulatory Assurance Department. I'm joined by my colleagues, Callaghan, who's also a Senior Policy Officer, and Martyn, who's a Senior Case Officer. First of all, we're going to give an overview of the right of access and touch on some key SAR-related issues that you may encounter in your organisation. After that, we are going to look in more detail at 3 areas where the ICO has updated our policy position recently so that we can explain in a bit more depth what our new position is. At the end, we'll have some time to answer some of your questions. You can hopefully see a text box where you can send us through your questions. So after the presentation, we'll try and get through as many of these as we can. So now I'll hand over to Martyn to get us started.
Okay, thank you, Rebecca. So as a brief introduction, I'd like to provide an overview of the right of access or subject access requests. So an individual is entitled to request confirmation that you process their personal data, a copy of their personal data, and other supplementary information. The requirements for this right are set out in Article 15 of the UK GDPR. There are no formal requirements set out for what makes a valid request. SARs are equally valid in whichever format they are received, and they can be made to any part of an organisation. This means that individuals are entitled to make verbal requests, such as during a telephone call or even in person. So it's recommended to have a policy in place to help deal with such requests. Similarly, if your organisation has a social media presence, a request using a social media site is equally valid. It's important to recognise this possibility and prepare to be able to respond accordingly. It will usually not be appropriate to supply the information by social media, and you should ask for an alternative delivery address. When it comes to who is responsible for responding, it's the data controller who is responsible for responding to a SAR. Organisations who use a processor should have contractual arrangements in place to help the controller deal with SARs properly. So this includes if the request is sent to either the controller or the processor, and then the processor should help the controller meet their obligations. So on the next slide, we're going to have a look at whether individuals can make a request on behalf of somebody, and indeed requests can be made on behalf of individuals, and an individual may even prefer a third party to make a SAR on their behalf. The UK GDPR does not prevent this, but you need to be satisfied a third party has the appropriate authority to act on an individual's behalf. It's not stipulated in the UK GDPR who can make a request on behalf of a third party, so it can be anyone with the appropriate authority. Examples might include a friend, relative, or a legal representative. It's also the third party's responsibility to provide evidence they have authority to act on behalf of an individual. For example, a written authority signed by an individual which states that the third party is authorised to make a SAR on that individual's behalf. Electronically signed letters are fine as long as an organisation is happy authority to act is in place. There are also other mechanisms which can be considered, such as power of attorney, but organisations should check what the power of attorney entitles the third party to do. If there is no evidence of authority, you do not need to comply with the SAR, but you should advise the third party of this. If you are concerned the individual does not understand the degree of the information the third party may be requesting, you can contact them first and they may agree for you to send the information directly to them. So in the case of third-party portals and online providers, SARs can be made through portals who assist individuals in making such requests. First, you'd need to determine if you need to comply with a request from a portal or online provider. So you would need to consider if you have been made aware an individual is making a SAR, if you are able to verify the identity of the individual if this is in doubt, if you are satisfied the portal has the individual's authority to act on their behalf, and if you are able to view the SAR without having to take proactive steps, such as having to pay a fee to retrieve it. If you have to take proactive steps to discover a SAR has been made, then you have not received a valid request and do not need to respond until the requirements have been met. It's the portal's responsibility to provide evidence they have authority to act on behalf of the individual. If you have any concerns about disclosing the information via a portal, including security concerns, it's good practice to contact the individual first. If the individual agrees, you should then send the response directly to them. If you are unable to contact the individual, you should advise the portal you will not respond until the relevant criteria have been met. And lastly, for this portion of the presentation, we'll consider children and young people. So the right of access is to a child's information remains their own rather than anyone else's. If you receive a SAR for personal data of a child, you should consider if the child is competent enough to understand their rights. If the request is from a child and you are confident that the child can understand their rights, you should usually respond to the child directly. A parent or guardian can act on a child's behalf if they have authority or if it's clear it's in the child's best interests. A child can authorise a third party to make the request if they are competent. If the child isn't deemed competent, it's usually appropriate to allow the holder of parental responsibility to exercise the child's rights on their behalf. However, there may be occasions when you need to be careful in deciding whether to disclose the information. For example, you may need to take into account any court orders relating to parental access or responsibility, or any duty of confidentiality owed to the child. You should also consider any consequences to the child of allowing access to their data or any detriment to them by not allowing that access. Assessment of a child's competence is considered on a case-by-case basis, and if you have regular contact with the child, this should be straightforward. If you do not, then a common sense approach, which gives due care to the sensitivity of the data involved, should be taken. So for the remainder of our time, we're going to focus on 3 areas that represent new policy lines from the ICO on key issues related to subject access requests. We'll go into a bit of detail about each of these because they are areas we've had lots of queries about in the past, so it's worth clarifying what our position is. These 3 issues are time limits for responding to SARs and when you can stop the clock, manifestly unfounded and excessive SARs, and the circumstances in which you can charge a fee. I'll now pass over to Rebecca, who's going to be talking about timeframes when responding to SARs and the circumstances in which you may stop the clock or extend the time limit.
Thanks, Martyn. So there is a high expectation on you to provide information in response to a SAR. You should make reasonable efforts to find and retrieve the requested information. It's your responsibility as a controller to make sure that your information management systems are well designed and well maintained so that you can find and extract information in response to SARs, and if necessary, so you can redact data about third parties. However, you aren't required to conduct searches that would be unreasonable or disproportionate to the importance of providing access to the information. You're only required to make a reasonable search. So when you're trying to work out whether a search might be unreasonable or disproportionate, you need to think about the circumstances of the particular request, any difficulties that there might be involved for you in finding the information, and weigh these up against the fundamental nature of the right of access and the importance to the data subject of having access to their information. But the burden of proof is on you to be able to justify why a search is unreasonable or disproportionate. It might be the case that searching for some of the information requested would be unreasonable or disproportionate, but in that situation, you still have to search for any other information within the scope of the request. And you should also consider whether asking for further information from the person making the request will help you to find the information they're looking for. So I'm going to talk now about timeframes for responding to SARs, and in particular the issue of when and under what circumstances you can have more time. So as you'll know, you must comply with the SAR without undue delay, and at the latest within 1 month of receipt of the request. You calculate the time limit from the day you receive the request until the corresponding calendar date in the next month. Occasionally that might not be possible, because the following month is shorter. Say you receive a request on the 31st of March and the next month, April, only has 30 days. In these cases, the date for response is the last day of the following month. If the corresponding date falls on a weekend or a public holiday, you have until the next working day to respond. What this means is that the exact number of days you have to comply with a SAR varies slightly depending on when the person makes the request. For operational purposes, you might need to adopt a consistent number of days. And in that case, it might be helpful to adopt a 28-day period, and that way you can always be sure that you are responding in the time limit. You can sometimes ask for clarification on a request before responding. If you process a large amount of information about an individual, and if you genuinely need more detail about the request before you respond to it, you may ask them for clarification about the information or the processing activities they want to know about before responding. You can ask them to provide you with more detail about the information they want to receive, such as the context in which you may have processed their information or the likely dates when you processed it. And this might help you to narrow down the information they're interested in, which will be beneficial to them as well as you. However, you can't force an individual to narrow the scope of their request. They are still entitled to ask for all the information you hold about them. So if you request clarification and the person responds simply repeating their initial request, or if they refuse to provide any extra information, you must still comply with their request by making reasonable searches for the information. So an example to show how this works, suppose that you are the DPO of a GP practice and you receive a SAR from a person who simply asks for all the information you hold about them. This person was previously employed by you as a receptionist for several years. They are now retired, and so they're no longer an employee, but they remain registered as a patient. All the information the practice holds about that person will include extensive HR records, plus all of their medical history going back several years. In circumstances like these, it would be reasonable to ask the person to clarify their request. You should explain to them that while they are entitled to request all the information held about them, the practice is only required to conduct a reasonable search of their records, and this might mean that they only receive some of the information held about them. It's important to explain to them that by clarifying their request, you will be able to focus your searches on locating the specific information they want. So they then might come back to you and clarify their request by saying, okay, I would like details of my employment from 1993 to 2008. I would like my medical records relating to an accident in 2018 and everything else you hold about me. And you can then focus your searches on the first two inquiries and then perform a reasonable search of the rest of the information. So you shouldn't seek clarification on a blanket basis every time you receive a SAR. You should only seek it if it is genuinely required in order to respond to a SAR, and if you process a large amount of information about the individual. And importantly, this is the updated policy position for us. This time limit for responding to the SAR is paused until you receive clarification, and we call this stopping the clock. So when you ask for clarification, the timescale for responding will stop until the person clarifies their request, and it will resume on the date you receive clarification from the requester. So when you receive a request, you should calculate when the response would normally be due. If you have asked for clarification, you may extend this time limit by the number of days that you stopped the clock. So suppose you receive a request on the 14th of May. The time limit starts from the same day. You have 1 month to reply, which means you need to respond by the 14th of June. However, if you ask for clarification on the 15th of May, the clock stops from the 15th of May until the date the person responds. So if they provide you with clarification on the 18th of May, the timing will resume on that date. So the clock was stopped from the 15th of May until the 18th of May. That means you can extend the original 1 month deadline by 3 days, and you should provide a response by the 17th of June. So if you need clarification, you should ask for it quickly and without undue delay after receiving the SAR. That will help enable you to focus on searching for the information the individual wants at the earliest possible stage, and it will make sure that you have enough time to respond. It's up to you whether you request clarification, as long as you are satisfied that you hold a large amount of information and it's not clear exactly what information it is the individual is asking for. You may request a clarification, but you don't have to. You may choose to perform a reasonable search instead. So you can only request clarification if you process large amounts of information about an individual. Whether or not this is the case will depend on the size of your organisation and the resources available to you to deal with SARs. A large volume of information might be less of an issue for a big organisation that has significant resources dedicated to responding to SARs. However, if you're a smaller organisation, you might be processing the same amount of information as a larger one, but have fewer and less sophisticated resources. And you're therefore more likely to be able to argue that you hold a large amount of information and you need clarification. And another thing to consider is whether, because of the volume of information you hold about someone, whether you are unlikely to be able to locate and retrieve the requested information by performing a reasonable search. Essentially, it's unlikely to be reasonable or necessary to ask clarification, even if you process a large amount of information about the person, if you could still find and provide what they're asking for quickly and easily. So in other words, you have to make a judgment on a case-by-case basis whether you need to ask for clarification, but you shouldn't do so as a blanket policy. You need to make sure that the process of getting the clarification you need is quick and easy for the individual. And as far as possible, you should provide advice and assistance to help them clarify their request. You should explain to them that the clock stops from the date that you ask for clarification, and it will start again once they respond. And you should also let them know if they need to reply to your request for clarification within a certain time. In addition to being able to stop the clock, you might also be able to extend the time limit for responding to SARs by 2 months if the request is complex or if the individual has made a number of requests. However, and this is important, a request is not automatically complex just because you need to seek clarification. Whether a request is complex or not, again, that depends on the specific circumstances of each case. What might be a complex request for one organisation might not be for another. The size and resources of your organisation are likely to be relevant factors. So you need to take into account your specific circumstances and the particular request when determining whether a request is complex. And you can find more detailed guidance about complex requests and the things you need to consider when making that judgment in our detailed guidance on our website. The important thing is that you need to be able to demonstrate why a request is complex in the particular circumstances. If a SAR is asking for a large amount of information, that might add to the complexity of a request, but a request is not complex just because the person's requesting a large amount of information. So as I say, you can find more information in our published detailed guidance about timeframes, about stopping the clock, and about complex requests. I'm now going to pass over to Caroline, who's going to talk about our other new policy lines, manifestly unfounded and excessive requests, and when, if ever, you may charge a fee when responding to a SAR.
Okay, thank you, Rebecca. Since the public consultation, we've updated the guidance on manifestly unfounded and excessive requests. So as you're aware, if you deem a SAR to be manifestly unfounded or excessive, you can either refuse the request or charge a reasonable fee and comply. A request may be manifestly unfounded if it's clear and obvious that an individual has no intention of exercising their right of access. You should consider the context and circumstances in which a request is made. you must be able to prove that an individual is not genuinely seeking to access their information. So this may be obvious if, for example, a person explicitly tells you they want to cause disruption, or they make unsubstantiated accusations clearly prompted by malice about you or specific employees as part of a grudge or targeted campaign. Sometimes you might have to deal with a number of requests before you can deem a further request unfounded. For example, in cases where a person systematically sends different requests to you on a daily or weekly basis as part of a campaign to cause disruption. In other cases, it may be possible to deem the first request you receive as unfounded. For example, if a person says they don't really want their information but will withdraw their SAR in return for financial benefit. It really depends on the circumstances, and it's important that you consider each request on a case-by-case basis. A manifestly excessive request is one that is clearly or obviously unreasonable. In the guidance, we've adopted a wider definition of what amounts to an excessive request, which considers the grounds of proportionality. It should give controllers more confidence in refusing disproportionate requests as manifestly excessive. You should decide whether it's proportionate to respond to the request when balanced with the burden or costs involved. Just because someone requests a large amount of information does not mean their request is excessive. In deciding whether a request is excessive, you should take into account all the circumstances, including the nature of the information, the context of the request, and your relationship with the individual, whether refusing the request may cause damage to the individual, your available resources, whether the request repeats previous requests and a reasonable interval has not elapsed, or the request overlaps with other requests. You should also explore alternative options. For example, you could consider making reasonable searches for the information, or if you receive a vaguely worded request and you process a large amount of information about the individual, you might consider asking them to clarify their request instead. So you should tailor your approach depending on the circumstances. Sometimes it might be appropriate to only provide the individual with any new information you hold about them since responding to their previous SAR. However, what is appropriate will really depend on the circumstances. You should consider each request on a case-by-case basis and ensure that any decision to deem a request excessive is fair and reasonable. You should also record the reasons for your decision. Okay, as a general rule, individuals have a right to access and receive copies of their personal information free of charge. So in most cases, you cannot charge a fee for complying with a SAR. However, you may charge a reasonable administrative fee if a request is manifestly unfounded or excessive, or an individual asks you to provide further copies of their SAR response. Alternatively, you can refuse to provide the information. If you are charging a fee, you can take into account the administrative costs of assessing whether you hold the information, locating, retrieving and extracting the information, providing and communicating the response, even if you're not providing the information, and that's likely to be the case, for example, if an exemption applies. If there's some overlap across these activities, you should ensure that you don't double charge the individual. You don't have to comply with the request until you've received the fee, but you should ask for the fee as soon as possible. You should also allow the individual a reasonable period of time to respond, and a month will normally be appropriate. You should never ask for a fee purely to extend the period of time you have for responding to a request. A reasonable fee might include the cost of photocopying, printing, postage, or any other costs involved in transferring the information to the individual, or the costs of making the information available remotely on an online platform. It can also include costs of equipment and supplies. And our new policy line allows controllers to charge for the cost of staff time. You should base the cost of staff time on the estimated time it will take to comply with the request, charged at a reasonable hourly rate. This may include locating, retrieving and extracting the information and putting it into the required format, and the cost of transferring the information to the individual, including, for example, photocopying and postage. You should also consider the overall reasonableness of the fee rather than focusing only on the precise activities you undertake in complying with the SAR. If your records are badly maintained, it may take staff longer to search for the information, and individuals should not be penalised for an organisation's poor record-keeping practices. You can charge for the physical costs of redaction, including the cost of materials such as tape or ink, but not for the time taken to think about what to redact or whether any exemptions apply. You should ensure that you charge fees in a reasonable, proportionate and consistent manner, so it's good practice to establish an unbiased set of criteria on charging, which explains the circumstances in which you'll charge a fee, your standard charges, and that can include a cost breakdown where possible, for example, the cost per A4 photocopy, and how you'll calculate the fee. You should explain the costs you'll take into account, including the cost of staff time, and it's important that your criteria is clear and accessible. It's good practice to explain your costs to the individual, and you have to be able to justify the costs if a complaint is made to the ICO. In the guidance, we've explained that it's not necessary to publish your criteria for charging, and that's because fees can only be charged in very limited circumstances, and it's more important that individuals are aware of their general right to access their personal information free of charge. I'm now going to pass back to Rebecca, who is having a look at some of your questions.
Thanks, Caroline. Right, to start, we've had a couple of questions coming in about emails, and so it might be worth saying something about this. We've had a couple of people asking questions like, does this apply to all emails sent from a company email address, or if an ex-employee asks us to see all emails that mention their name, are these kinds of requests covered by the right of access? So is there anything we can say about emails?
Yes, we can. We actually have an example in the right of access guidance on emails. Obviously, what is personal data depends really on the content and context of the information. Just because an individual is named on an email does not mean that the content of the email relates to them. So in situations where an individual is only named as a recipient and only their name or email address is visible on the email, their only personal data is in fact their name or their email address, so sufficient to let them know that this is the information you hold in respect of 2,000 emails or however many emails it may concern. You know, it's fine that you take that approach.
Great, okay. Let me, another question I just saw that I thought was quite useful. What do you do if you request further information, you put in a request for clarification from a data subject and they don't respond? What effect does that have on your timescale for responding to the SAR?
I'm happy to take that if you want, Caroline. So if you are requesting clarification, then usually it requires you to go back as soon as you can to the data subject to ask for that information. If you've not actually received anything, we generally consider a usual time period of roughly a month before it can start to be considered closed. So the clock will stay stopped until you receive the clarification that you requested. But if you get nothing back from the data subject, generally a reasonable period we would consider to be a month before you then consider that request closed.
We've had a sort of related question about stopping the clock, which is asking, does the clock also stop if you are asking for verification of the identity of the requester? So if you need further proof that they are who they say they are, does the clock stop then?
Well, generally the clock doesn't start until you've got proof of the individual's identity, but in general you shouldn't really be asking for proof of identity unless you actually need it, and it needs to be reasonable and proportionate. Obviously, if you're stopping the clock to ask for clarification about the request itself, you shouldn't delay asking for proof of ID. It's important that you don't delay responding to the request. So unless it would disclose personal data to an individual until you've actually confirmed their identity, we'd recommend that you would ask for clarification at the same time as requesting ID if that's possible.
Great, okay. Sorry, I had a good question to ask and then I've lost it. So we've had a question coming in about the format in which we provide you provide access to the information. So is there any obligation to provide printed materials in response to a SAR, or is it okay simply to make electronic copies available if that's what is easiest for you as an organisation?
It's a good question. I'm happy to take that, Rebecca. So the format in which you respond to a data subject's request is usually dependent upon how you've actually received that request in the first place. So if you've received the request in an electronic format, the GDPR encourages that you respond in a commonly used electronic format. So for example, you might go back by email and provide it in software that is commonly used. Unless the data subject makes a reasonable request for alternatives. So, for example, it might be something to do with a reasonable adjustment or a service adjustment or something along those lines. If you've received the request in writing, or if, for example, through the post, or if it's been made verbally, then there's more sort of consideration about you going back in the best way. You could still go back electronically. But you could also go back in sort of through the post as well.
Okay, a question here. So we're a large private care and education company. We have around 10,000 staff and clients. It says we receive around 12 SARs a month, and these range in size from a few documents to sometimes over a decade's worth of care records. And these can take our DP and compliance team weeks to complete, which we're happy to do, but we struggle to keep up with the caseload alongside many other compliance responsibilities. So what are the recommendations for large organisations in assessing the resources that should be allocated for SAR work so that we can balance data subject rights with what we can practically deliver in a financially viable way?
Okay, well, in general, you are required to perform reasonable searches for information when you receive a SAR, and really how an organisation allocates resources is really down to them. It's not something we could provide, very specific advice on, to be honest. But what we would say is that, the same options are available for larger organisations as they are for smaller organisations. So you might want to look into, depending on the circumstances, whether it's appropriate to stop the clock. Obviously, you need to meet certain criteria before you stop the clock, but it can apply to larger organisations in the same way as it applies to SMEs. Obviously, what amounts to a large amount of information for an SME is going to maybe amount to a small amount of information for a larger organisation. But certainly, if you hold huge amount of information about an individual across different databases, or the individual is known to you in a different capacity, for example, they're a client or a patient, and they're also an employee, and you hold third-party information about them, for example, if relatives or friends or clients or patients. I mean, certainly you could make an argument that it's appropriate to stop the clock to ask for clarification in those circumstances. Your other options are deeming a request to be excessive if it's for a large amount of information or complex, for example. Also, what I would say to any organisation really is to make sure you plan and have processes in place for dealing with SARs. Obviously, it's a really good idea to have templates drafted up. It will save you time. It will save your staff time. It means that when you get a SAR, your staff will know exactly what to do. If certain exemptions are relevant to you, explore those. Explore when they might be relevant to the information you hold. If you do hold a very specific or niche set of personal information about data subjects. So generally, it's really just exploring the options that are available to you, and obviously you're required to conduct reasonable searches.
Thank you. There's a question here that says, if an ex-employee makes a subject access request that you suspect is just because they are disgruntled, can you decline to respond to the SAR?
I'll take that one. I think if you suspect that it's being made just because they are a disgruntled member, a former member of staff, you'd probably need a bit more sort of burden of proof really in terms of going down the route of saying it's manifestly unfounded or something like that. So I think Caroline touched upon this earlier in the presentation. You'd be looking at being able to justify the fact that the individual clearly has no intention to exercise their right of access, or if they were maybe looking for something in return, or it's malicious in intent around harassing the organisation or something along those lines. I think it would have to be considered on a case-by-case basis in all circumstances, and you'd have to balance that against the fact that they may actually be wanting to sort of exercise their legal right of access. So you'd be looking for levels of proof in terms of showing that it would be manifestly unfounded or something along those lines as to why you can refuse the request. But you even in a circumstance where you refuse the request, you would still need to respond to the SAR.
Thank you. So we had a question of saying, can we respond to the subject explaining that because we have had a number of other requests from other data subjects, therefore the response will be delayed? So if we have a number of, if we are overwhelmed with subject access requests, can we inform the data subjects that our response will be delayed because of that?
No, only if the same data subject has made the request themselves. Obviously, you can extend the time limit if you receive complex SARs or repeated requests of information from the same data subject. But if you're receiving a large volume of requests from different individuals, you can't use that as a basis for delaying someone's request. I understand that in the context of third-party service providers, controllers do get quite a lot of information about different people, but it's just not possible for them to delay responding, because you can't penalise people for, say, appointing the same third-party service provider to act on their behalf. We can't penalise between people who choose to appoint a third-party service provider and those who don't. I mean, that's often the situation when these kinds of circumstances arise.
Mm-hmm. Somebody asks if you can require data subjects to make their request in writing, or if you can require them to use a particular template or your own kind of online portal in order to make their SAR.
Yeah, I'll take that one as well. So in essence, you can't really make a data subject make their request in any particular format. So that goes back to the part of the presentation where I spoke at the start, which says that a request is valid in any format. So it can be made in writing, it could be made via email, it could be made over the telephone or even in person. So you can't really specify that the request has to be made in a specific format or submitted in writing, quoting particular words or something along those lines. That's not to say, though, that a form might be useful. What you can still do is you can still have a form that you can encourage people to use, and they can be useful to organisations that receive subject access requests, because they can then prompt the information that they'd like from people, make it a little bit easier in terms of sort of responding to the SAR and how to find that information and getting the information that they require from the data subject. But the short answer to the question is yes, you can use a form, but you can't force people to use it, and you'd have to consider that requests that aren't made via a standard form are still obviously valid SARs.
Thanks. Are instant messages covered by SARs, such as conversations in Microsoft Teams?
Well, yes, if they contain the personal information of the data subject and it's in a work context, I mean, they do come within the scope of a SAR.
Mm-hmm. So a question here about third-party service providers. Can the behaviour of third-party service providers be considered if we're declaring a request unfounded? Sometimes these providers encourage people to make pointless SARs in return for gifts or benefits. We also sometimes get bulk requests from online portals for different clients. Can any of these be considered manifestly unfounded or excessive?
Yeah, I'll take that one, Rebecca. Generally, no, you can't really take into account the behaviour of a third-party representative when sort of making or deeming a request to be unfounded or excessive. You should only really consider the behaviour of the individual and the nature of their request. So it's not really fair to then hold individuals accountable for the behaviour of people who are representing them, and penalising them might deter them in the future from actually using representatives, which they're perfectly entitled to do. So basically the answer comes down to it is the behaviour and the circumstances around the individual request that need to be considered.
Right, we've got just 4 minutes left, so we've got time for perhaps a couple more quick questions. Question about whether the ICO plans to publish template letters or sample responses to SARs, as some organisations think this might be helpful.
No, we're not planning to do that, no. We actually don't think it would be necessarily helpful for us to publish template letters or sample responses, and in fact it could be counterproductive, and that's really because the guidance needs to be relevant to a large number of organisations and sectors. So it would be very difficult for us to produce generic templates that would be relevant to all of those sectors and all of those organisations. Obviously, SAR responses are going to vary considerably depending on the type of organisation and the type of information you hold, how sensitive the information is, and we don't expect controllers to apply the guidance in the same way. We'd expect controllers to tailor the guidance to suit their specific circumstances. And it's really important that SARs are dealt with on a case-by-case basis. And I think, as I mentioned earlier in response to another question, it's a good idea for controllers perhaps to produce their own templates. They're obviously the experts in their own sector, and they understand the type of information they hold and the type of information that is going to be subject to particular exemptions, for example. So it's good practice for organisations to maybe consider producing their own templates, because obviously that will save them time in the long run.
Okay, let's have one final quick question. Do we have to respond to the SAR if people have another way of accessing their information?
I can take that. Yes, you do have to respond to the SAR. I mean, there may be other ways of accessing information. For example, if there's legal proceedings, there may be, other ways of other court mechanisms of accessing information or discovery process. However, individuals may make a SAR for their information as well. Obviously, if they're making the SAR, to circumvent any other processes that are in place, they may not get all the information they're looking for on the basis that they're only going to get their own personal information. So they will have third-party data redacted from the information that they receive. So depending on what their purpose is, it may have limited use for them. And obviously controllers can explain that to data subjects, but you can't prevent them from making a request for their information. You have to make it clear to them, yes, they can make the request for information. But obviously, if you're aware of other processes in place that they could be using, you can also suggest that, but make it clear that they can make a SAR.
Great, thanks, Caroline. Well, we're out of time, so we'll have to wrap it up there. Thank you, everyone, for attending. Thank you for your questions. I hope this has been a useful session and has helped to clear up any questions you might have had about subject access. If there's anything we didn't get around to answering today, hopefully you can find the answers to that in our detailed guidance on our website, which covers every aspect of subject access requests in depth. And that's it. Once again, thank you very much for coming.